let's get going here. So thanks everybody for joining us today. I'm Lee Cuellar from Keller Williams. We've worked with Paulina at MT Evictions for many years, and our families, I don't know how long our families have known one another, Blanc and Irma and Rosa and Angelica and all of them. But anyway, anytime we have eviction issues or we want to know what's happening with rent stabilization, et cetera, in most parts of Southern California, we lean on Paulina and her company at MT Evictions to help us and to help in turn help our clients, which is even more important, right? What will become very clear to you guys and all of us today is that you need an eviction specialist to counsel your landlord clients. That's just the truth, because I don't think I have the time. I know that my agents don't have the time to study at the depth of which that Paulina and her gang do at MT Evictions, right? So without any further ado, here is Paulina, and we'll do Q&A at the end of the last 10-15 minutes or so, if that's okay, Paulina. And feel free to use the chat box for those of you who are shy and would like to ask questions. All right, Paulina, take it away.
Thank you, Lee, and thank you so much for hosting this. I know you were waiting on me, but I did not want to host a webinar until we more or less had a handle of what was going to happen. And last Friday, as expected, the governor extended the eviction moratorium with new rules and regulations. And I'm here to touch on that. I'm going to do my screen share. I do have about 8 slides, but after the 5th slide, I will be taking Q&A. And like Lee said, if you're shy, please feel free to put your questions on the chat. So could everyone see my screen? Okay, awesome. That is our team members. I'm not just a one-woman show. I hope I never will. And my amazing team is here to answer questions whenever I'm not available. That is our contact information as well. And for those that don't know about me, I've been doing evictions for 16 years now. My name is Paulina Martignon, and although we do evictions, that's our last resort, especially in this day and age. We want to make sure that our client is maximizing their time and their money for their property. So we're here to make sure that you have proper rental agreements, proper changes of terms, buyout agreements, so on and so forth. So we're here to protect the landlord community. Now I'm going to move on to the next slide here, and I'm going to go straight into what's going on now with the COVID moratorium in place. So as we know, AB 3088 is the Temporary Tenant Protection Act. It's temporary. Well, we shall see how long this lasts for. But as of now, it is categorized in 3 different phases. So I'm going to go with what's prior to COVID. It's rents owed from March 1st, 2020 and beyond. So during this period, in essence, we're supposed to be able to do evictions, but I'm really not recommending that because a tenant could still claim COVID, and that eviction is going to be frozen until further notice, especially right now with the new extension of the AB 3088 Tenant Protection Act. Now, we enter into phase 1, which are rents owed from March 1st through March 31st. We're calling this phase 1. So in essence, if tenants owe rents during this period, a landlord is entitled to issue 15-day notices. The 15-day notices must have a series of different forms. So we call it a bundle for phase 1. It's a 15-day, it's a notice to tenant regarding COVID, it's financial declaration forms along with state forms. So if the tenant responds within 15 business days that they had suffered financial hardship due to COVID, that is sufficient to buy them immunity from eviction. And just like that, the eviction procedure is frozen. Now, tenants are supposed to repay the rent during that period, and it depends on your local jurisdiction. the time frame that the tenant's going to have. So for example, if your property is in LA City, you're subject to LA City rent control. That area has determined that renters will have 12 months to pay back rent owed from that period. That period started on September 1st, 2020. So, which means in essence, your tenant has until September 1st, 2021 to pay back rents owed any time from March through August. After that period, if the tenant did not pay you the rent, then you are free and clear to commence a small claims action against them for rent owed for phase 1. Now we're going to move on to phase 2. Phase 2 is rents owed from September 1st, 2020, and it has just now been extended to June 30th, 2021. So rents owed during this period, a renter buys immunity from eviction if they pay 25% of the rent for each month after September, plus if they issue their financial declaration forms. So all a tenant has to do is issue 25% of the rent plus their financial declaration form, and they're free from getting evicted. Now, after July 1st, 2021, a landlord may pursue a small claims for the balance, which is a 75%. Now, prior to starting either a small claims or an eviction after July, the landlord has to show proof that they notify their tenants, their renters, of rent relief programs and or that they applied, which is going to segue me into the next slide. The next slide deals with the current protection rights that were just approved starting on Friday. So first and foremost, and some of them are old from the inception of AB 3088, and some of them are new. So number A, or letter A rather, landlord may not charge any late fees from March 1st through June 30th. So if a landlord has charged late fees, those need to get credited towards rent owed. Now, starting now, payments cannot be applied retroactively. And this is starting this month, February 1st, 2021. So this means if your renter paid you $500, which is a partial payment, and they owe rent from June of last year, we could no longer apply it towards back rent owed. It has to be for that current month. So this is new. Traditionally, a landlord wants to apply it towards back rent owed to clear old rents. As the jurisdiction for evictions, it's only a 12-month period. And a jurisdiction for small claims is a 3-year period. So the point of landlords clearing or rent is so they don't miss the opportunity of not being able to collect on that rent. But starting February 1st, 2021, landlords are not going to be able to apply any payments towards back rent owed. Now, C, landlords may not transfer or assign rents owed to a new buyer. So this is new on our real world of real estate. Traditionally, we ask the sellers or the realtors that if they're going to sell a property with renters, in order for the buyer to be able to enforce future evictions, if the renter owes rents, to assign them to the buyer so the buyer could pursue an eviction or pursue the claim for those rents. So as of February 1st, we're not allowed to do that anymore, which means once you sell the property, the seller will still have the right to collect rents owed during that period in a small claims action. So the buyer purchases the property, let's say property closed on February 1st, 2021. They no longer owe old rents. It's new moment. new rent log per se. Okay. Now, D, landlords must notify tenants of the rent relief programs in writing. Also, there's a new mandated notice that our office is giving away. If you're interested in obtaining that mandated notice, please email our team. I'll share my email in a minute. And that notice must go out by February 28th, 2021. If that notice does not go out by February 28th, 2021, a landlord is not going to be able to evict for those rents, but only go after it in small claims. Okay. Now, the rent relief program is being on the works as we speak. It's a federal funded program. And the website is supposed to be available by March 15th. That's the deadline that the federal government has issued for the program to be up and running. So by March 15th, 2021, the program is supposed to be available 24/7, 7 days a week for landlords and tenants to start submitting their applications. Now the program, the federal program, is going to cover 80% of rent owed only from the period of April 2020 through March 2021. So it's covering only that period. Now, let's say your tenant has made partial payments and they now have a balance of $5,000, that they're only going to cover 80% of the balance owed. So I am recommending, don't record this, Lee, to talk to your tenants, let them know, hey, I'm going to claim you haven't paid me the rent from April to March. The rent that you have paid me, I could apply it to rents after March. And the reason I'm bringing this up is because most likely there's not going to be additional funding or help after the March deadline. And the way I see our California government moving, most likely this bill is going to extend to at least the end of this year. So the federal assistance, it's only going to be from April 2020 through March 2021. So if your tenant is on board, I would suggest to do so. So you could at least tap into 80% of that time frame. Okay. Now the landlord is going to have to waive the balance of the 20% owed. Now a question I'm getting is, Paulina, what if I don't want to partake and I don't, want to waive because I don't want to waive 20%? I mean, right? My initial response is like, we're screwed. Really, this is a mob. The way the government is presenting it is, if you don't take the 80%, once you go to court and you need to evict, we're going to give you that 20% reduction cut. And if the tenant has proof that they qualified for the program, but the landlord didn't take it, they will be sanctioning the landlords for not taking the assistance. So it's really not worth to say no. Okay. Now I do encourage you all, and at the end I do have a slide for you to write to our governors and our governor and our assembly people writing these bills and asking them to take a cut of 20% out of their paychecks or their retirement, because that's literally what they're asking landlords to do. Okay, but we'll get to that when we get to that slide. Now, I am suggesting clients to use this time to attempt a buyout or send settlement letters. I'll waive the amount of rent that you owe, move out. At this point, it's a business decision because landlords are being held hostage from their properties, and an eviction is not going to be a realistic approach. We are filing evictions, but evictions are being litigated by these defense firms because the money is there to fund the defense firms. So defense firms are just sitting like sharks, waiting for cases to come to their office so they could tap into that governmental funding. So out of 10 evictions we filed last month, only one did not get litigated. And we won that one in default because there's nobody fighting the case. But if it's an LA County case, 90% of the time, those cases are going to be litigated. San Bernardino, Riverside, Orange, it's a whole different deal. We're not seeing defense attorneys jump onto those cases just yet. Okay. Now, forcing technicalities. Once we're ready to start evictions, if there's any illegal rent increases or improper rent increases, it will be an issue. So we are asking landlords to have their portfolios be reviewed by a professional. Make sure that you have done everything correctly and up to date in order to not jeopardize your case or your rights to go after that money. Now, also another big issue that I foresee is absentee updated addendums as per the new law that came into play last year, January 1st, 2020. So I'm gonna roll back the film, take you back to January 1st, 2020. From the inception of the year, the state of California decided that we should have rent control. Although Prop 10 was voted down by Californians, they still felt that we should have rent control. So as such, 85% of the properties in California are now subject to rules. Now, it's not a one size fits all because besides state, we have county and then we have city. So this is where the layers come in. And five properties in one block could have 5 different rules and regulations because it comes down to when the property was built, who owns the property, is it owned by an individual, an LLC, how many units on the lot, so on and so forth. So depending on those factors is the governing rules that a landlord needs to follow. And in order for the tenants to know what rules they're subject under, the landlord is responsible to update the tenants with these addendums to their rental agreements. So that was supposed to be done by last summer, August of 2020. Now, what happens to the landlords that didn't do it? So let's say you have a single family home that you're renting. Traditionally, you would not be subject to rent control, but because you didn't send that addendum saying that you're not subject to rent control, that you're exempt, you're now automatically part of rent control until the tenant signs an addendum. So this is why it's very important to have a professional by your side. Otherwise, it's very easy to make a mistake in this litigation world. Now, I'm going to take questions now because I know that's a lot of information to digest and it could become very loaded. Lee, feel free to facilitate any of questions that we may have.
Very good. So those of you that would rather type into the chat box, go right ahead. And I'll keep an eye on it while Paulina's answering other questions.
Perfect. Question I have here from Mr. Albert. Can we get an email of the slides? Yes, of course. You could email my team. I'm going to share that information now, and I will issue a copy of the slides along with the mandatory new form. So it's mtevictions@gmail.com. Please allow 24-hour turnaround because we are getting bombarded right now.
Here's a question from Adriana. What if the tenant left the property on their own? That sounds like a blessing, but still owes rent.
Adriana, that is a blessing, and now it transitions into a small claims, and that option will be available after July 1st, 2021. But your renter still has the opportunity to apply for the rent relief program and get 80% of that rent paid. So your responsibility will still be to communicate with the renter that this rent relief program is available for him before you attempt a small claims. Next question from Mr. Vargas. What department will be serving? I don't understand your question, Sergio. Could you please? I know you're not shy. Could you unmute yourself and ask?
Yeah, I apologize. I was actually driving when I typed that. I wanted to ask what department will be helping with the applications? What government department?
Good question. As soon as I have the website available, I'm going to share it on my Facebook and, of course, to all my clients. It is a federal funding program, so it is going to be a federal website. And the federal government, once the application is submitted, they're going to assign hub centers. So, for example, let's say you're in unincorporated LA, they're going to assign Alma Family Services to service those applications, so on and so forth.
All right, here's a question.
Did that answer your question?
Yes, it did. Thank you so much. I was eating chips, so I muted myself. Sorry.
Thank you, Sergio.
TMI. Here's a question from Adrian Alvarado. So the tenant in Colton, San Bernardino County hasn't paid rent in 10 months. Can they be evicted with proper notice of rent relief programs?
Good question. So San Bernardino is awesome. We're loving San Bernardino because they are actually allowing us to do evictions.
Oh.
Nice. As such, I'm not closing my doors completely yet. So yeah, as long as we do the proper format of the notices in San Bernardino, we're able to proceed.
Right.
And let me clarify that if the tenant does not respond as they're supposed to, that's when it gives us the green light to proceed. If the tenant does respond with the financial declaration and paying the 25%, right. They bought themselves immunity from evictions. And
if they claim COVID, then they have even more time.
They have to claim the financial declaration form along with the 25% of the rent from phase 2.
Got it.
Yeah. I have a question here from Theodore. For this bill, does it only apply for tenants that can claim COVID hardship? So if someone has the ability to pay, okay. Unfortunately, this is not a fair world. The government is not putting the burden of proof on the landlord, on the tenant, but rather on the landlord. So technically, a tenant could claim that they're having financial hardship, even if they're not, and it still buys them immunity, and it needs to be litigated in court. And as we know, litigation nowadays, it's not a transitional paperwork. Now it's a lot of fees involved.
Híjole. Clarissa asks, I hope I didn't say that out loud. Clarissa's asking, if your property manager failed to properly implement all these new rules, is my LLC still liable? And if so, what can we do? Good question, Clarissa.
So, yeah, that's a great question. And technically, the person that shall and will always be liable is the person on title. So if the LLC is the person on title, then it doesn't matter that you hired a property management company because a property management company normally provides management services. They shouldn't really be providing legal advice, so they're not fully responsible, nor liable. The liability falls on the property owner.
Right. Lulu Robles, thanks for the question. Properties in the city of Compton, buyers buying a tenant occupied property. Once buyer becomes the new owners, I'm guessing, can a 60-day notice be given to the tenant? So do you get
short
that?
Answer is no. Yes and no. There's never a come on, guys, you guys know this. There's no answer. Technically, we could serve notices. It is perfectly legal to serve notices, but it's perfectly illegal to proceed with them. So yes, I would serve a notice, and I would segue that into a buyout. But if the tenant does not vacate, we cannot file an eviction until the local county moratorium is lifted. So if you would have given me this scenario, Lulu, in San Bernardino and Riverside and Orange or Kern County, we could do it. LA County is not allowing evictions until after February 28th, 2021. I do foresee them extending this. So to answer your question, yes, you could serve a 60-day notice. When could you actually enforce that notice? Is that known? I would segue into a buyout.
Can I ask regarding that?
Yes, of course.
So with what you just said, so this is whether or not the tenants are claiming any financial hardship or with anything with COVID, because the burden of proof now lies on the new, I guess, the new owner.
Correct.
We get that. Okay, that's what I wanted to know.
Correct. Yeah. So the way this is working is, according to AB 3088, a landlord could issue a 60-day or a 30-day for landlord occupancy or for the sale of a property. So that is why we could do that in certain counties, because certain counties are not adding additional restrictions. And we are following the state regulations on that. So once again, the counties I mentioned are mostly conservative. They're not gonna, they don't believe in rent control. As such, we just have to follow what the state says. Those areas, we are doing 60 days, we are doing evictions. LA County, a whole different story. LA County has us on a complete moratorium for no fault eviction. This would be considered a no fault scenario. Okay,
I'm sorry. We have one in Alhambra, and it's they want to be owner occupied, and there's a couple in there right now. They've paid their rent, but the lease is up, so they can't give them a 30-day or 60-day notice. And if they willingly leave.
So technically, yes, you could issue a notice. If they leave, perfect. If you reach an agreement, even better. If you reach an agreement, you want to back that up with we call it buyout agreement. Otherwise, the tenant could easily turn around and claim a wrongful eviction and as such sue. Now, if the tenant decides not to agree and not to move out, we will have to wait until LA County lifts the no fault moratorium. As of right now, is due for February 28th. Most likely it will get extended though.
Okay, so when you say buyout agreement, meaning like maybe $2,000 to help them with moving costs or something like that?
Yes, anything goes. Okay. So before I answer a couple more questions, I'm gonna go on this slide and then I'm gonna answer more questions. So what could we do? What could we evict for, right? So besides LA County that we can't do anything right now, any other county, we could evict for landlord occupancy, for breach of lease or contract, for non-payment of rent or non-compliance to the 15-day notices, for a governmental order, for public health and safety and illegal activity. So those are the reasons that we are able to proceed for evictions. I'm gonna stop my screen share for a minute so I could see all of your beautiful faces, because it looks weird, feels weird just looking at a screen. And I'm gonna answer more questions, and I have a couple more slides, and you know, I'll continue with Q&As. So I have here a question from, I lost my place. I know there's a couple here. Rick, if someone's violating the lease, such an illegal subleasing violation, HOA rules, et cetera, could we evict? The answer is yes, so as long as we're in, not in LA County. LA County, after February 28th, I'm gonna know if we could proceed on those grounds. Let's see, Gabriela Pineda, this is a really good question. What if the tenant has left, but all of their belongings were left behind? How long do we have to store them? So that happens a lot. It's so funny. People leave their junk behind. But it's easier to deal with their junk than to deal with the humans. So that's good news. An 18-day notice needs to be issued. An 18-day notice for personal belongings. After 18 days, the landlord needs to take pictures. You could store them in a garage and an area where they won't get damaged, take an inventory list. So it's an 18-day notice. After 18-day notice, you have to wait 15 more days, and if there's no claim for the items whatsoever, I suggest to donate them to Goodwill, call Goodwill, have them give you a receipt that everything was valued under $750. If the items, AKA junk, are valued under $750, you don't have to go through an auction. Otherwise, you have to go through the animal of an auction, which is a whole different step, and I won't discuss right now. But you could always call me for a consult if you need further information. Let's see here. There's a lot of questions. Do you mind, Lee, helping me read some of the questions?
Yeah, let me read. So did you say you have the tenant relief program letter, and are they different for county areas versus cities? Or is it the same one?
Love that question. So
Good
it's
question.
a universal letter for the whole state. Thank God the government did something universally.
Good.
And if, depending on your city, you also have to attach your city order. The only cities that have their own orders is Pasadena City, Culver City, and LA City. So any other city, you just worry about one. All the other cities I mentioned, you have to do two.
Wow.
Let's see, the next question is, I have a former client who's selling a home in Santa Barbara. In November 2020, guys, these sound like insulting questions. Let's see how many I could get through. In November, her agent asked if her daughter and her friend could occupy the home until it was sold. The agent agreed to pay my client $5,000 plus expenses per month. As of now, the home has not been sold and the agent has not paid the agreed amount. What is the recourse? I need more details on that. This is touches into a lot of legalities and not just the landlord-tenant perspective. This is more of a contractual law, so I would have to review the actual agreement to give any suggestions.
All right.
There was no agreement at all. There wasn't a written agreement. It was just a verbal agreement.
Oh, boy.
Then it would be a small claims issue.
Okay, thank you very
Okay,
much. Mhm.
not a problem.
So
What will be required from landlords in order to qualify for the 18% reimbursement of missed rents? This question is from Jason. Jason, in essence, everybody qualifies. Now, the money is going to be issued due to level of priorities. There's going to be 3 different tiers. Tier 1 is tenants that make under the 50% of the median income. Tier 2 is tenants that make from 50 to 80%, and then tier 3 will be the rest. Next question, what if a tenant has not paid months prior to March 2020, but they're now claiming COVID? Do they still have immunity? This is a tough question, depending on the county. If you're asking me this in LA County, my answer is gonna be like, we're dealing with a very democratic council. Chances are the judge will grant them immunity. If you're asking me in this question in any other county, I'm gonna say we have a pretty good shot. Let's do it. So it comes down to, it's all politics, folks. I'm sorry. I wish it wasn't, but it is. I'm gonna get to one more question, then I'm gonna go back to the slides because I just realized we're almost at 40 minutes and I don't wanna lose your attention. Let's see. LA City, LA Rankin Building Own LLC, can you increase the 10% for additional tenant during the moratorium? And do we have to take extra tenants or can we refuse? Rosa Gastelum, you're one of our regular clients. If you want to show your face, that would be nice. It's going to be a long answer.
Awesome.
So technically, the landlord has the right to claim their 10%. So my recommendation is don't miss your window of opportunity, because in LA City, the window of opportunity is only 2 months, 60 days. If the landlord did not voice an additional occupant or a breach within 60 days. After 60 days, it becomes okay. It becomes part of the agreement and you can no longer do anything about it. So yes, issue your 10% increases. However, because we are in a moratorium in LA City, technically you cannot enforce it until the moratorium has been lifted. The moratorium of LA City it's different than the state moratorium. And as I have said before, it's supposed to expire on February 28th. Is it going to be extended? Most likely, but still put in your notice so you could exercise your rights later. So this is the thing right now with landlording. If you don't put in your notices now, you're bypassing your rights for later. So although you cannot enforce it now, if you don't exercise your rights now, you will lose your rights later. Now,
okay,
can you
hear me?
Yeah, so let me answer your part 2 of your question,
Okay.
Rosa. So do you have to take extra tenants? In LA City, you cannot refuse additional tenants. You have to give the opportunity to have additional tenants. So unfortunately, you have the right to ask for a rental application and to do your 10%. And if, for example, they have really poor credit or they don't want to do a rental application, then you could refuse.
Okay, so my question was, if once we give a 60-day notice to let them know that their rent will be increased for 10%, do we have to disclose that at this time we will not be accepting it due to the moratorium? Or do we just serve the notice and then just tell them verbally? That's one of the questions. And then the other is, if these are troubled tenants and they're trying to put in more tenants, is there a limit on the amount of tenants we can accept? Or if she says, oh, I have 5 more people moving in, do I have to accept them?
Very good question. Don't hate me, hate the government. There's no limit. I had a situation where they had 25 people in a studio, and I suggested our client to call the health and safety department to see if they would flag it for the amount of people. And the health and safety department said there's no regulations of how many people could live in a unit. As such, they couldn't flag the property. So to answer your, sadly, no, there's no limit. And I would issue the notice and let them know verbally. Technically, you could start paying it once the moratorium is over.
Thank you so much.
Not a problem. So I'm going to go back to the slides just to make sure I don't forget any important information. And then depending on the time, we'll get a couple more Q&As. Yeah, let's see. So this is where I want to get to. Please, 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 landlords, make your voice heard. Get loud about your rights. And don't email. It's easy to ignore emails. It's harder to ignore 10,000 letters are coming from angry landlords. So please ask the government to take a pay cut on their payment and their retirement, because that's literally what they're doing for the landlord community. And these are the 3 major personnel that you need to be writing to. Also, we donate to the AOA, the Apartment Owners Association. The website is right here. They're constantly suing the government for these ludicrous draconian rules, but they need funding. With the funding, the more money in the pot, the more lawsuits they could get in. So when people ask me, well, what are you doing? I'm like, well, you is we. So I said, let's get together and fund the association that's constantly advocating for our rights. And pretty much we only serve the realtors, investors, property managers, and landlord community. Don't send me your tenants, please. We serve the counties of Orange, Riverside, San Bernardino, and LA. The services we offer are, besides landlord consulting services, case analysis, tenant buyout agreements, rental agreements, legal letters, small claims, commercial and residential evictions. And our fees, I know everybody asks, what are your fees? I always forget to disclose our fees, but here it is, screenshot it. We do charge for consulting. I'm sorry, I know some of you get upset over this, but I do have to pay overhead. Otherwise, I will have to close shop like the only other 5 eviction companies on my bullet board, and I don't want to do that, team. So let's work here together. And last but not least, I am part of Morrison Home Inspections. So if you do need a discount on your inspections, use the promo code MT2020, and the Morrison office will honor your discount on your home inspection. Now, how much more time do I have, Lee, for questions?
Paulina, we've got 15 minutes.
Okay. So instead of reading, I'm going to allow a couple of you to unmute yourselves and ask the question so we can make it a little bit more interactive.
Hi, Paulina, it's Lulu.
Lulu, let me take Josue because he's on the big screen, and then you're next. Hi, Josue.
Hey, how are you? Good to see you.
Good to see you.
Yeah, we continuously work together, but we have a transitionary period, right, where 25% is due, and now that got extended to June. How does that intertwine with like the 80%? Like how are they calculating these formulas once those funds are available?
So the 80% will only be covered for April 2020, rents due from April 2020 through March 1st, 2021. So unfortunately, it's not covering phase 1 or 2 in its entirely. It's only covered partial months, right? Now, the 80% is out of the balance owed for that period. So if from let's say from April through March, your tenant only owes $3,000 from that period, they're only covering 80% of that period. As such, it is recommended to let your tenants know, hey, let's create a win-win. The rents, if you get approved for the program, the rents that you have paid from this period, I'll apply it to rents after March, and this way they get a break. And in hindsight, we of course tap into the maximum of the 80% during that time.
Got it. Cool.
Make sense?
I think so. Thank you.
Awesome. Now, did we already email you the notice, or do you already have the notice that needs to be sent out by February 28th?
Got it.
Okay. Make sure that goes out each month. Okay. All right. Awesome. Thank you, Josue. Lulu.
Yes, Paulina. So real quickly, are we allowed to increase rents in LA County or not because of the moratorium?
Yes and no. So LA County is big, right? We have Alhambra, we have Pasadena, we have Downey, so on and so forth. So this rule comes down to local area. So LA City rent control, it's not allowing increases, and unincorporated LA are not allowing increases, but every other area they are. So if, for example, you're asking me this in a property in Alhambra, my answer is going to be yes. Downey, yes. Pasadena, yes. The unincorporated parts of Pasadena, no. So it comes down to area. Now, you can have a property in LA City, and it cannot be subject to LA City rent control. It could be subject to state rent control or no rent control, which means those properties you could. So unfortunately, this is where I don't have a yes or no, a clear answer. It's not a one size fits all. It comes down to individual property. Okay.
Okay. So if I call your office and give you the address, then you can tell me whether I can or not.
So what we do is we do property research for $25. You get all the information you need to know about that property. What needs to get fixed, what you could do, what you cannot do, so on and so forth. So yeah,
Okay.
we ask 6 different questions in order for us to throw back all this valuable, awesome information.
Okay, thank you.
Thank you, Lulu. Yes. And Clarissa's asking if you can have copy of the slides. Yes, anyone that's interested on the slides and on the free form, email our team. Please give us about 24-hour turnaround to get to everyone's email. Oh, I'm missing a M there. Evictions@gmail.com. Okay. But I think that covered most of the questions.
Paulina, how does the rent assistance notice, how does that need to be delivered? Is there a specific way, like via the mail, or is email okay? Or
My recommendation is always going to be mail, regular mail, traditional mail, via delivery confirmation. Delivery confirmation is a white slip.
yeah,
Don't do register return receipt. Don't do email, because unfortunately in court, text messaging and email, it's not up to par with what's appropriate. So yeah, I would do that as extra, but mainly delivery confirmation.
delivery confirmation, great.
I have a question.
So,
Jesse. Can you hear me?
Yes, I can, Jesse.
Hello?
Yes.
Excellent. You mentioned there's a new letter, Lee, a new letter about the 80% compensation. However, you just told a different gentleman that we should hand that every month. Now, are you, because the monthly notice is the COVID release, where, what is it? I can't pay because of COVID. I don't remember the name of that notice.
The new
So-
mandatory notice, the new mandatory notice with this Assembly Bill 91 is the notice
Yes.
that is mandatory by February 28th. And every
Okay.
month that goes by from now until June, that the tenant does not pay, you have to reissue that notice in order for the landlord to not lose the right to collect that rent in the future. So that's separate from the
And this-
COVID notice, that is separate from the financial declaration form. Unfortunately, right now, and this is the confusing part, there is about 5 different notices that have been mandatory since the inception of COVID. So they all play a different role throughout the space.
Are we talking about the rent relief program? Is that what we're telling our tenants about?
The new form is pretty much the new rules under Assembly Bill 91. And it also mentions about the COVID relief program that will be available. Now, once the program becomes available, then that's a separate letter that needs to go out to your tenants, letting them know, here's the link, here are the resources. Plus, if there's local resources, then you have to add your local resource. Example, Pasadena has a local rent relief program. LA City has its local rent relief program. LA County, Downey. So depending on your local area, you have to give them all available resources besides the federal resource. And by the way, I just found out that Pasadena is actually giving loans for ADUs. I thought that was pretty cool.
Yeah. Interesting.
Now I
the
want
way-
a single family in Pasadena just to get an ADU.
No, you don't. You don't, trust me.
I have a quick question.
Yes.
For some of these notices that are being mailed out, let's say you don't send it certified, but you do send it with a certificate of mail. Is that still valid?
I'm not recommending registered mail, period, because if a tenant does not sign for it, that's it. That's the dead end. So do it by delivery confirmation. Martha, bring me a delivery confirmation so I can show them what it looks like.
And what if the tenant refuses to sign for the certified mail?
So I'm gonna repeat, do not send it via certified mail. Do not. The tenant's not gonna sign. It's a dead end. You wanna
Okay.
use this form. It's a certificate of
Okay,
mailing.
certificate of mailing.
It does
Perfect.
not require a signature. It's just almost like a tracking.
Okay,
form.
perfect.
Awesome.
Okay.
And then just a quick, because it's a lot of forms, it's a lot of laws, and you know, there's going to be an owner and a management company that's going to miss a form, right? And then there's going to be the time where tenants are behind since March. And if you miss one form, how do you see this going about? Do you think there's going to be big problems in court? Do you think they're going to waive it? Okay, you missed one form, or is it going to be all for the tenants? And then if you miss one form, that's it. You're out of it. You're asked out of your rent.
So this is the thing. Way back when, in the 70s, actually, landlord tenant law was created in the 40s. When the law was created, evictions were considered a fast track type of law. So in order to bypass the regular time frame of a civil litigation, which was an average of 1 year, evictions were supposed to get a fast track immunity of the average eviction used to take about long eviction, 6 weeks to 8 weeks. In order for that to happen, the burden of proof 100% fell on the landlord, and the landlord had to make sure that they didn't skip a beat in order for them to get a tenant out within that shorter time frame. Now that's backfired, because now there's no way, with so many changes, that a landlord could be up to date in everything. But unfortunately, the jurisdictional law is still written that way. As such, it does come down to the discretion of the judge. LA County are very pro-tenant. They don't want to approve evictions because they have a bad rep of having the highest eviction numbers yearly. Once again, it's political, right? They don't understand that evictions are needed because nobody wants to go through an eviction expense. You do it because you have to. But anyhow, LA County, I don't see a judge for being forgiven to a landlord for skipping the beat. Now, if we're dealing with a judge in San Bernardino or Riverside, they're a little bit more forgiven. Their bottom line is, you had the opportunity to pay, why didn't you pay? Or, we're gonna do a rent reduction, but you have to be out, so on and so forth. But it really comes down to the judge. LA County, you're not going to be that lucky.
I have a question on if you send them a delivery confirmation, how do you prove that you send all the forms? Just take pictures before you send it?
You are supposed to keep a copy of the documents before. Good record keeping is what's going to be key here.
Okay. And one other thing is our tenants are not, well, the 3 regular tenants are not missing any rent, they're paying, but is it possible for me to send all 5 of the mandatory document, like you said, all at once? Like, I'm not claiming anything, but just to cover myself.
So your tenants don't owe rent?
Right, the 3.
I wouldn't do it, because then they're gonna know that they don't have to pay rent.
But I thought you said by February 28th it's mandatory.
Yes, when your tenants owe rents from March 1st. So it goes retroactive to March 1st. Now, if they haven't owed you rents, then you don't have to protect yourself for the future, because you don't have to go after anything. However, if next month they owe rents, then you issue it at that point.
Oh, okay. I'm so glad I asked this question.
Yes.
And then, but then the other tenant, who's a small business, they haven't paid anything since March of 20.
It's a commercial?
They're renting it for their
city.
Go ahead.
Los Angeles.
I need the city. Oh, Los Angeles. And are they month or at least?
It's rent control.
Okay. I need my questions answered, Brian. I'm sorry. If not, I can't help. Are you under a lease or a month-to-month?
At least.
So if you're under a lease, you have to wait until the lease is over. If you would not be under a lease, we could do a 30-day because it's commercial. Rent control does not come into play on a commercial unit. And by commercial, my definition of commercial is a business. They're using this facility to operate a business, not to live in. Clear?
And if
Yes,
they're doing both,
Can I still claim that 80% through the government?
Yes, you can. Are they going to help commercials? I have not heard of them helping commercials yet.
Okay.
Okay. Now, Lee, you brought up a good question. What if they're doing a mixed use? Then residential prevails. Residential law prevails.
got it.
Okay. All right,
Let's do that.
team. It's 5 o'clock. You've had me for an hour. Hope you learned a thing or two.
Yay!
Thank you so much.
Paulina,
No
thank you.
problem. I hope this was helpful.
Very helpful.
Definitely.
Very much.
Yeah, I know this is very complex. Out of my 16 years, I've never experienced such a difficult time in the landlord community. And
Yeah.
my heart goes out to every single landlord and you know, property manager and business owner right now that's going through this hardship, and things are so one-sided, but I know we will get through this. We just need to be diligent, do what we need to do to make sure we protect our future rights.
Awesome. Thanks, everybody. Thanks for coming, and drop an email to mtevictions@gmail.com to get copies of the deck. All right.
Thank you so much, Lee.
Thanks very much. Thank you. Thanks, everybody.